Welcome back to the Business Immigration Benchmark. We've got a bite-sized episode here today. I wanted to break down a recent headline for listeners. I know there's been a tremendous amount of headlines, and it can feel very overwhelming and honestly hard to digest. So today I'm going to talk about a headline that you may have seen or may have dropped to the bottom of your feed, so to speak. And it's about some changes in the DOJ, Department of Justice, Immigration and Employee Rights Division. There's been some changes there. And like I said, all these headlines have been super hard to digest. Let me take a stab at breaking it down for you and telling you why it matters and some practical significance that it may have or that you want to think about for your immigration program. So let's get into it. So, what is the DOJ's Office of Immigrant and Employee Rights, IER? Well, it's the office that's charged with enforcing anti-discrimination provisions of the Immigration and Nationality Act. And basically, the INA, the statute that this office is charged with supporting or enforcing, the INA bars consideration of citizenship status or national origin in the hiring, firing, or recruitment of employees. The IER also investigates allegations of intimidation or unfair documentation in verifying workers' employment authorization. So that's kind of the I-9 piece. And you're probably familiar with training your recruiters, your talent acquisition teams. You as an HR or global mobility leader are probably aware of what questions you are lawfully able to ask a candidate in the recruitment process. And that is because of this INA statute. Under the Biden administration, we saw the IER fine employers when an organization would require an application, require U.S. citizenship or legal permanent residence. This is complaint driven. And so if, an individual saw that the company was requiring U.S. citizenship or green card status to apply for the role, and that role was not an export controlled role, that the role did not handle, national security or technologies or any part of the supply chain. The role doesn't require actually the requirement of US citizenship or legal permanent residence. You can only require, or a company can only require, an applicant or an employee have US citizenship or legal permanent residence when the role and the work of that position supports specific export controlled items. This is often in industries like national defense, aerospace, some telecom, some electronics, like if they're making components. So even if the role is at one of those companies, if the role doesn't actually support those pieces or national security components of the position, then the company cannot require US citizenship or legal permanent residence. And that's where we saw fines under the Biden administration under this anti-discrimination statute that a company can't require certain citizenship status or national origin. I have an example, a company, it was under the Biden administration. A client of mine was a finance company, and recruiters accidentally listed that US citizenship was required for the role. Now, this finance company did not have any export controlled business, or the role would not be touching any export control work. Rather, it was a recruiter's mistake because sometimes on the online portals, this was through a US university, there's drop-down menus that are very limiting about type of applicants or roles that the recruiter accidentally hit US citizenship only to apply. That requisition or that posting was up on the university for maybe less than a week. And we saw that company unfortunately get fined by the IER. So the Biden administration was pretty active in focusing on this anti-discrimination part of their mission. Now, under the Trump administration, they're shifting the direction of the IER. So again, under the Biden administration, we saw them focused on enforcing the anti-discrimination piece of the INA for national origin and citizenship status. The Trump administration now is tasking the IER to review alleged discrimination against U.S. citizens. So this is with the intent to protect the U.S. worker and to look into employers showing a preference for foreign national employees, like those on visas or H-1Bs, for example. So the reason I'm paying attention is this is going to impact the way your recruiters are communicating, your HR is communicating, and you want to make sure that everybody's on the same page with understanding, of course, where issues can crop up. And you want to make sure you're coordinating with your employment counsel to make sure your employee handbooks are up to date. Of course, you're always doing that. You might have done that at the end of last year, but with this refreshed focus on protecting US workers, you might want to take a look at your employment policies to ensure that they're in line with this new focus and to make sure that the company is on the same page and that all, like I said, recruiters, the talent teams, the HR teams, managers are on the same page with how the company's talent acquisition strategy is on the same page. The biggest potential exposure that I see here from, someone that's managing your immigration portfolio, you're probably not part of the recruitment team, you're not, seeing or reviewing candidates, you're not putting out job requisitions. But the biggest potential exposure for someone managing a US immigration program is the PERM program. Of course, this is the test of the US labor market, and the Department of Labor requires, frankly, some antiquated methods of testing the US labor market, like two Sunday newspaper ads. I practically do not know any companies that are normally leveraging newspaper advertisements for their job hires or their requisitions, but rather under some recent lawsuits and settlements, we want to be making sure more than ever that the perm recruitment mirrors the normal recruitment process for your organization. So this is something that if you haven't already, in light of those lawsuits a couple years ago, had a refreshed look at your methods of recruitment, because recall that under the Department of Labor's PERM program, there are optional or you can select different methods of recruitment. You want to make sure that what you're selecting mirrors to the best of your ability or the company's ability the normal recruitment process for any employee or candidate. We saw in 2020, while Trump was still in office, this protect US citizens, protect US workers. We saw this before, and that is ultimately when his administration sued Meta in December of 2020, and Meta agreed to pay up to 14.25 million to settle the government's claims that Meta routinely refused to consider American workers for jobs it reserved for temporary visa holders. So this is something that we could see again. Again, we saw under Trump 1.0 scrutiny of some big tech programs, perm programs, and what we saw out of that was effectively the guidance to ensure that future perm recruitments mirror the normal recruitment efforts of a company. So this is something, again, not an immediate challenge or an immediate compliance issue, but something that you definitely want to take a look at with your employment counsel to have a conversation about what your perm program looks like today and what kind of risks your perm program may be under this new Trump administration, which will have a higher focus, a higher scrutiny of protecting US workers. And with that, you just want to make sure that your program is airtight and that you have a thoughtful approach to your perm recruitment, testing the US labor market. So if there were to be any complaints, and this is a complaint driven process, you have the right documentation, the policies in order to support your company and to support your immigration program. Well, thank you for joining me on this week's episode. And thank you to the listeners who have reached out, shared some thoughtful feedback. I really appreciate it. It means the world to me. If you're out there and you've got a comment, feedback, question, don't hesitate. Reach out to me on LinkedIn and drop me your thoughts. Catch you next week.